when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word, I am not getting on the stand?
It depends on how I wake up.
As you can see, we're in Atlanta, Georgia, continuing our coverage in the racketeering trial of Jeffrey Williams, also known as Young Thug. Thank you so much for coming back here to Law and Crime. Right now, I want to focus on the upcoming return of Kenneth Lil Woody Copeland, who said in the above clip that his willingness to testify will depend on, quote, how he wakes up that morning, end quote. Now, remember, Copeland is a star witness for the prosecution who was on the stand when the trial came to a halt after he participated in an ex parte meeting in June. The meeting involved prosecutors, former Judge Earl Glanville, law enforcement members, and Copeland's sit-in attorney, all to discuss Copeland's rights to testify under immunity after he attempted to plead the Fifth. The meeting excluded defense attorneys, and the case went downhill from there. So now fast forward to this week, where Judge Paige Whitaker decided Copeland's testimony would start over if he decided to testify on Monday. But if not, here's the consequences Copeland was instructed about on Tuesday.
The state is not interested in you pleading the Fifth, and in order to avoid you pleading the Fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later.
I have told the state I have lied and lied and lied and lied.
I know. And
so how are they going to be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
they said they're going to be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
Not prior. You've said you've lied and lied and lied in every. I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind, don't do that.
Can I give you an example for what they told me?
Yeah, yes, and then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the Fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right, what was the first one?
Pleading the Fifth.
Say it again.
Taking the Fifth, Judge.
Taking the Fifth, okay, right.
That exchange was quite something. And looking ahead to Copeland's potential testimony, of course, we still have Gwendolyn Lindsay Jackson and Roger Foley to talk about it. Gwen, Copeland doesn't have a great track record on the stand so far and has said to prosecutors that he's lied about his involvement with YSL time and time again. And despite multiple parties explaining his rights to testify, will he get up there and actually do it?
Well, I feel that because he's lied and lied and lied in the past, and now I guess the prosecutors are saying that, okay, because you've lied in the past, this is in the past, we're not going to throw you in jail for that. But if he gets up on the stand, he can't stop lying about stuff that he didn't say, and he's compelled to testify. He could face time. He could get thrown in jail. I don't think he should testify because, quite frankly, I don't think that he has the self-control not to lie about future things. And that's my honest opinion.
All right. Well, Roger, we want to get your thoughts here. If Copeland decides to take the stand, the parties have agreed to start his testimony over. Could this be problematic for the jury, or do you think they've forgotten about his prior testimony already, although he just, said he's lied before?
Attorney that I want to put a poster of this guy in my office, because if that's the state's star witness, this is like a dream come true. And every time he lies, it's going to come out during cross-examination. So the fact that he's saying this, I don't know why on earth the state would even want to put him on, because if they're relying on him as the key to winning their case, they don't have a case. So now, is this guy doesn't seem what we want in society, but from a defense attorney's, dream witness on the stand, he's the top of the heap.
Well, Gwen, we have several witnesses who have been offered plea deals to testify, and several uncooperative ones at that. Do these witnesses actually help or hurt the prosecution in the end, do you think?
I think it all depends on which witness you're talking about. Obviously, with the witness that we just heard, Mr. Copeland, he's obviously going to help, the defense. He's going to help the defense because he's lied and lied and lied. But it really depends. So you have to really thread this very finely, and it has to be very specific. It depends on who that witness is.
Roger, I didn't get your thoughts. Do you think that he's going to testify, and what do you make of this?
Well, I think if he testifies, it's only going to harm the state. They may get some information out of him, but through cross-examination, he'll be shredded. It's like putting an onion through a dicer. He's going to get shredded by the defense. So I don't think it's beneficial for the state to put him up.
By the way, this was a little comedic to us as we had a chuckle out of this. And Gwendolyn, I want to point out to you that yesterday, YSL himself was seen closing his eyes, taking a bit of a snooze, possibly. What is going through his mind as these motions are going on? This trial is the longest in Georgia history, and on top of that, the jurors haven't been back in about 2 months. What could everyone be really thinking here?
They're thinking mistrial. They're thinking this is going to all go away. It's just unprecedented, all the motions that are going on to get rid of the prosecutors. This is the third judge. You have witnesses that lie and lie and lie that the prosecutor wants to put on that are going to get shredded if they're cross-examined. He's thinking, this is going to go away. This needs to go away. There's no way we can lose. We're ahead.
Well, Roger, what did you think? Did you see that video that was just on the screen right now? It was a little bit comedic to see him close his eyes. This is the guy that's on trial. Look at that right now. That's not really the kind of defendant that you see every day in the courtroom, is it?
Well, no, we see a lot of defendants like that in the courtroom on a daily basis. But the key is, right now, there's no jury present, right? So if there was a jury present, and anytime any defense attorney lets their client know that when you're sitting at the table, you are being watched, you are being critiqued. So what you do, your actions, you're the nodding of the head, the rolling of the eyes, the falling asleep at a table, people are going to critique that one way or the other. Now, since there's no jury, what does it mean? But can he, if once that jury gets back, can he get out of that habit of, oh, I'm just so sleepy, or this bores me and we're ahead? If he's in that mindset, you might have some jurors that go, hey, this guy's being charged with these crimes and he thinks it's a joke. We don't think it's a joke. We're away from our families. Never discount what a jury is thinking, I guess, is the key to it.
Well, getting back to Lil Woody Copeland here, Gwen, do you think it would help the prosecution at this point if he does not testify based on all the things that he's come out to say?
Well, he's a nightmare. I really do not think he should testify. It can only harm them. It's really like the textbook example of the prosecutorial witness that you do not want on the stand. He's going to get shredded. He's lying all the time. And he's going to do it again. And then the other thing is, I believe Mr. Copeland, he has an attorney himself. So he's going to be consulting with his attorney in terms of whether he should testify. And his attorney is probably very worried in terms of whether or not he can stop lying and possibly expose himself to future crimes.
Roger, what do you think?
I 100% agree. He's going to get shredded. So, I mean, and as a defense attorney, we've all had that client that you don't want him on the stand. But in this case, you know, he is a witness. He's been given this immunity, but it's not going to be good. So obviously his defense attorney just wants the state not to call him and for them to move on.
Would the defense, you think, would have a right to ask about the ex parte meeting for Copeland?
Oh, yes, yes. They definitely need to ask about that, because all those facts and hidden agenda or hidden things that have happened, the defense, they need to know about that. And the fact that they were not a part of it, that is alarming. They were not a part of that ex parte communication. You're not supposed to have ex parte communication with the judge, period. Really.
A lot of it is very alarming, Gwen. So we're going to just have to see how this trial unravels. I mean, at the rate this is going, it could end in 10 years. I mean, who knows? All right. We're going to take a quick break, but don't go anywhere, because we're going to continue our Young Thug racketeering trial and also take a closer look at what outstanding motions are still on the table, and there are a lot of them. We'll be right back.